take your time coming up. There's no rush. Whenever you're ready.
May it please the Court, my name is Rachel Nordby, and I'm here with Joe Mellichamp from the Attorney General's Office on behalf of the Department. I would like to reserve 5 minutes for rebuttal. Under Florida's tax code, every sale or use of tangible personal property is taxed unless there's an express statutory exemption. No sales or use tax has ever been paid on any of the vehicle parts and repairs at issue in this case, and no exemption applies. Here, the trial court adopted a contract law theory that is inconsistent with both Florida law and the facts in this case. Under this contract theory, General Motors argues that these repairs have already been taxed as part of the original vehicle sale, but that's incorrect for 3 reasons. First, these repairs were not taxed at the time of the original vehicle sale because they were separate transactions that occurred years later. Second,
but weren't they funded out of the original sales price? And I'm not sure that's dispositive, but
no, they have not. That's not been proven. There's an issue relating to whether that has been proven, but the trial court ruled that that was not determinative of the issue.
Well, how are basic warranty repairs then treated for tax purposes?
For tax purposes, basic warranty repairs are expressly exempt under statute 212.0506 subsection 10. It expressly exempts them under a manufacturer's or factory warranty.
Well, it seems to me that the central question then is whether this goodwill repair program is like a basic warranty, part of the consideration flowing to the purchaser when they buy the car.
Judge Van Nortwick, there is no consideration flowing to the purchaser related to these goodwill repairs.
And why is that?
Because General Motors asserts that the consideration is a right to participate and seek these repairs. However, by definition, these repairs are not warranty repairs. They occur after the warranty is expired. Therefore, any right that they have allegedly purchased to these repairs, it's not enforceable. There's no contractual right to them. And
but
they cannot.
The trial court found, and I think there's evidence in the record, that there were 400,000 goodwill repairs at a cost of nearly $300 million. Surely that was a benefit to some of their customers.
Well, the amount of the repairs provided for tax purposes, relating to the consideration issue, it's not relevant because we're looking at the time of the vehicle purchase, did the consumer receive some contractual right to these repairs?
But didn't
they did not.
Owner's manual explain the benefit to the customer of the goodwill repair program?
No, it did not.
Wasn't that part of it? Am I mistaken? I thought I'd seen that.
Okay.
No. The owner manuals, there were 5 complete warranty manuals in the record, and they contained 3 differing versions of the language that General Motors states is at issue and gives notice.
The trial court relied on one specifically.
That is an issue we raised. The trial court ignored 4 versions of the manual and relied on only one, which did discuss that at some point we may provide these repairs, but even that language contains no express or implied promise that any consumer could ever bring a claim on to enforce their right.
Counsel, isn't the duty of good faith applicable to GM's obligation to address consumer complaints?
No, Your Honor, it's not. And this is very critical. The trial court erroneously speculated that any discretion GM had under this program would be governed by the implied covenant of good faith and fair dealing. But in Florida cases, all the ones that address them, they recognize that to bring a breach of contract claim based on this implied covenant, a party would have to be able to point to an express term and promise in the contract that has been breached in order to invoke this implied covenant. And here, there is nothing that no consumer could ever point to bring a breach claim under this implied covenant. And it's important, because it's an implied covenant, the law requires that it be anchored, and that's a very strong word, anchored to an express term of the contract. Otherwise, a court or fact finder could just alter a contract at will based on what it subjectively deems to be fair.
Okay, what if GM had set up this program, had very specific guidelines? I'm not sure all this is in the record, but I'm just giving you an idea. Set up this program in-house, put aside this money, saying, here we had this program, we're going to put aside this money for it, and not told the consumer, but it was something that they had given the consumer, Would that, in fact, at that point have been consideration, even though they didn't tell the consumer?
No, it would not be consideration. And in fact, our position is that they never told the consumer. Based on the warranty manuals in the record, there's no mention of this repair program, but it would not be consideration because to be consideration, something must be bargained for and it must induce a party to enter a contract. Here, consumers had no notice of this program, the scope of the program, or the terms of the program. Therefore, it could not be bargained for consideration because they did not know about it and they could not have been induced by it.
Okay, the trial court relied on, I think it was a 2002 manual in its order.
Yes.
Talk to me about a couple of things. Number one, why isn't the language in the 2002 manual sufficient to be consideration, telling them about a program here? GM, and I'm reading off the order, under certain circumstances, General Motors and dealers may provide assistance after a limited warranty period has expired when the problem results from a defect in material or workmanship. And then it goes on and talks about the arbitration. Why is that not a promise that can be tied to? If there's a defect in material or workmanship, we're going to deal with it. I mean, why couldn't the trial court have read this particular language as being a promise?
Because this language contains no promise that any consumer could ever enforce. It's just notice that at some point down the line, we may provide something for the benefit of our consumers, we may not. It just provides notice, and it contains no promise that could ever be enforced.
The Michigan Supreme Court, in a similar case, made the following statement: GM's promise pursuant to its case-by-case goodwill adjustment policy, while discretionary with respect to whether there will be any adjustment, is not discretionary regarding GM's obligation to act reasonably and in good faith in response to a customer complaint. Would you agree with that statement?
No, Your Honor,
why not?
The language in the warranty manual that they say establishes this contractual theory from which consideration flows. There's no promise or guarantee contained in it. And it's important to note, getting to the warranty manual issue, in the record, there's 5 complete versions of the warranty manual. The trial court relied on the 2002 version, which does mention the case-by-case repair program. However, the 2000 Chevrolet manual in the record, all it says, this language at issue that they say establishes a promise: your Chevrolet dealer is best equipped to provide all your service needs. In the event you have any questions or concerns, talk to a member of dealer management. It never says anything about what occurs after the warranty manual ends. And in order to invoke the implied covenant, Florida cases recognize that you cannot alter or supersede the express terms of a contract. And here the warranty.
I was going to ask you to address how the language in the other warranties that are in the record differs from the language in the 2002, but part of the key to me here is a potential difference, is that it talks about a problem resulting from a defect in material or workmanship, which would seem to imply that if there is a defect in material or workmanship, we're going to deal with it somehow. You understand what I'm saying? I'm not sure that language exists in the other
And
portions.
no, it definitely does not exist. The language is very materially different in the other versions in the record. The 2002 manual, although it does say when a problem results from a defect in the material or workmanship, it's still completely discretionary as to who may down the line come in and eventually receive one of these repairs. There is nothing enforceable in this language or any of the other warranty manual languages in the record. So even though it states defect in material or workmanship, it uses, may provide assistance, reviewed on a case-by-case basis. That is nothing that any consumer could ever come into a court and bring a breach of contract claim based on in order to enforce this right that they have allegedly purchased. So, and additionally,
Okay, you're down about 5 minutes.
okay. And real quick before we get there, I would like to bring the court's attention to documents we submitted in our reply brief appendix at tabs 2 and tabs 3, where General Motors, in its own documents that it gives to dealers establishing what goodwill repairs are, it repeatedly disclaims any contractual obligation for goodwill repairs. And I'll reserve the remainder of my time.
Your Honors, may it please the Court, my name is Dan Schluter, and I represent the plaintiff appellee General Motors here. In this case, the trial court correctly determined that it would violate the state's long-standing prohibitions on tax pyramiding for the state to impose a tax on these repairs.
Okay, counsel, I'm going to interrupt you real quick because I want to have some questions in my mind I want to deal with immediately.
Sure.
Do you have the judge's order available to you?
Yes, Your Honor.
The judge says on page 9 of that order, I believe, or page 2 of the order, right below the warranty language, the essential core issue here is whether the above language creates a legally enforceable contractual right in the customer. Do you agree with the judge's statement that if there is no legally enforceable contract right, that seems to be his ruling, if there's no legally enforceable contract right, this was not taxed at the beginning?
Your Honor, I do agree that we win if that's the issue and that's the determination.
So I'm asking you whether you agree whether that's the issue. I mean, I understand your arguments that you're going to make. But my question is, does there have to be a legally enforceable contractual right for that to have been considered to be consideration?
Your Honor, there is a legally enforceable right.
I understand you're saying there is a legally enforceable right, but you're ducking my question, I think.
Let me just answer it directly then. I don't believe it's necessary.
Okay, and tell me why.
I think it's a harder question.
That seems to be what the trial court relied on, so tell me why.
I think it's a harder question if it's not enforceable. But the question here is tax pyramiding, right? What the statute says is we want to impose one tax on retail sales, not multiple taxes. We don't want to unnecessarily burden commerce in that way. And so the question is there tax pyramiding? And to one of the questions that was asked earlier, we have 400,000.
Can there be tax pyramiding? Forget the 400,000. I don't want to go there yet.
Okay.
Can there be tax pyramiding absent consideration that was given in the contract?
Your Honor, I believe that there can be, and we gave an example in our brief. People all the time, they go into a store and they can choose to go to a high-end department store and pay more because they think they're going to get better treatment, better service from that store, and they're going to pay more for a product than they would if they went down the street to some discount outlet and got the same product. And so there's a higher price that they're paying for benefits that may not be contractually enforceable.
Okay, well, the trial court didn't agree with you on that argument. If I read that paragraph, because he goes on and says, the fact that GM estimated and factored into the price a charge for the vehicle's cost of the goodwill repairs is not controlling. So he seemed to think in his order that there had to be a legally enforceable contractual right. Also, it appears The Michigan case you rely on seems, even though you won in that case, seems to say there has to be a legally enforceable contractual right. So aren't you asking us to go one step further than any other court has gone in determining whether that is taxable? You understand my question?
Yeah, I don't believe that Your Honors have to go that direction. There is clear precedent, obviously, from the trial court and from the Supreme Court of Michigan here, which decided this exact case involving GM's program, which found that there was a legally enforceable.
Okay, let's go there for a second.
Okay.
The trial court, in determining that there was a legally enforceable contractual right here, specifically relied on the language from the 2002 manual. That concerns me, because we weren't just dealing with the 2002 year. Why shouldn't we have to send it back to the trial court for a look, even if we buy your argument, to look at those other years?
I don't think you have to send it back, Your Honor, because you have the warranty manuals in the record here before you. Those warranty manuals, the difference between what the 2002 manual does is it makes explicit what was already implicit in those earlier manuals. And if you look at the language in the earlier manuals, and if we take a look at the trial judge's order, what those earlier manuals contain is the first sentence here, which says, should you ever encounter a problem during or after the limited warranty, do these things, and it sets out the procedure.
On this point, counsel, the judge for submission, what is our standard of review of the trial court's determination?
It's a summary judgment ruling, so it's de novo with respect to the court's legal determinations. The state concedes in its brief that this issue of whether it considered the right manuals, that's reviewed under a clearly erroneous standard of review. But in terms of the question,
are consumers as purchasers of these vehicles placed on notice at the time of purchase of the existence of GM's goodwill repairs?
Your Honor, they are, well, first of all, there's no evidence in the record one way or the other whether consumers know about these things. There weren't consumer surveys presented by the state. Their assumption is that consumers don't know. But the
question was whether or not they were placed on notice.
Your Honor, through the warranty manual, yes. And the Michigan Supreme Court, in its decision, which had the earlier manuals, the manuals from the 1990s, which are the manuals that the state now says faults the trial court for not citing in its opinion. That was the version of the manual. That was before the Michigan Supreme Court, and Michigan Supreme Court said explicitly, based on that language that I just read, should you ever have a concern during or after the warranty, the Michigan Supreme Court found that the manual put customers on notice of the program.
I'm not sure I understand this. They were dealing with language other than the 2002 owner's manual.
Correct, Your Honor.
So if you didn't have the language quoted by the trial court, you would say the results should be the same?
Absolutely, because that was the same result in the Michigan case. Reviewing
Wasn't
that,
the language in the Michigan statute somewhat different, if I can remember correctly? Because it specifically had a definition of pyramiding in there, didn't it?
No, I don't believe so, Your Honor. The specific provision in Michigan was Michigan Law 205.94, and what that provision says is that you can't impose use tax when sales tax has already been imposed. Florida has the exact analogous position in 212.06.
If GM provides a partial goodwill repair rather than the full repair, are consumers charged sales tax on the portion of the repair cost?
They are charged on the portion that is not covered by the case-by-case program because, of course, they didn't pay tax in connection with the underlying vehicle sale on that portion. The portion that is not subject to tax is the portion that is covered by the program, and the reason for that, of course, is that they are simply getting the benefit for that portion of the repair. They're simply getting the benefit of what they previously paid for and were taxed on by the state. Coming back to a moment.
Let me go back a moment as well, in reference to the manual. Is there any language in the warranty manual that's notice of the procedure for obtaining a case-by-case repair that binds GM to the future performance of any obligation as repair in its good faith dealings?
Yes, Your Honor. As the Michigan Supreme Court found, we have a duty to consider these requests and to act on them in good faith. And the reason for that, the implied duty of good faith, attaches to every contractual obligation, including ones like this one that contain a discretionary element. And that was the holding of this court in the Cox case. It was the holding of the second DCA in the Seep case, which was decided by the trial court.
Under Florida law, the good faith element cannot be used to create a contractual obligation. It only explains it if there's discretion. And it looked like what the trial court was doing here was saying, well, I've got this provision that clearly uses the word may, so there's no binding obligation there. But if we tack onto that the good faith obligation, then we do have a contractual obligation.
The manual says not just may, it says we will review these requests on a case-by-case basis. And so
but may provide assistance. I mean, you will review it, but you may fix it.
And that's the discretionary element. Right. And the fact that a promise has a discretionary element, and it's been a long-standing precedent, obviously going back many years, the Lady Duff Gordon case, I think, is probably the most famous from the New York court. But certainly in Florida, the law is no different here than it is in Michigan, which is that the implied duty of good faith attaches to this discretionary promise and does impose a duty on GM as a result. And that is a promise and a benefit that customers achieve and obtain at the beginning of the transaction, at the outset of the sale. And so for that reason, what the customer is obtaining in connection with goodwill repair is simply the benefit of what they have already paid for and already been taxed on.
Counsel, with regards to GM's case-by-case approach to this goodwill repairs, is it possible for similarly situated customers who purchase the exact same vehicle, go to the same dealerships with identical post-warranty mechanical defects at or near the same time, to receive different outcomes?
Anything is possible, Your Honor, whether that person would have a right to bring an action, because based on all the facts and circumstances, the dealer did not exercise good faith and GM did not exercise good faith, they may have a claim.
But hasn't GM taken the position that they don't have a claim?
Well, there's discretion here, certainly, and there's no question that this program is...
Well, how about the documents that they've attached, that they talked about, that said GM takes the position that there is no legally enforceable right under this good faith program?
What those documents say, read in context, is they say this is not a legally enforceable right like the warranty, and it's not. As the trial court clearly stated correctly, this program is designed to be more discretionary. We're talking about vehicles now that are 4, 5, 6 years old.
It seems to me that it's like being a little bit pregnant. Either you have a legally enforceable right or you don't.
Well,
is there a legally enforceable right under this program? Has GM taken that position?
Your Honor, there is a legally enforceable right. It's a question of what's the legally enforceable right, what does it consist of? And what this program provides, as the Michigan Supreme Court found, is a legally enforceable right to a discretionary determination by the dealer informed by explicit guidelines.
So the legally enforceable right is to have GM, and you might be right. I'm being, the legally enforceable right, as I understand it, is to have GM consider it. But if GM doesn't do what you like, you don't have a legally enforceable right.
The legally enforceable right is to have the claim reviewed in a good faith manner. And it's very clear that consumers who feel that that GM did not live up to that good faith obligation, they may have a right to sue.
What are the other than the 2002 manual, which talks about looking at the defect in material or workmanship, because that seems to be some kind of standard of what GM is going to look at. What in the other manuals tells the consumer what GM is going to look at?
The other manuals talk in terms of, it's a more general statement in terms of problems, but the guidelines that GM provides to dealers, which are longstanding, go way back into the early 90s. One of them, I think, is attached to the appendix that the state filed, say explicitly that this program is designed to address defects. And then it sets forth a whole series of questions that the dealer should ask in determining whether to provide a repair under the program, all designed to get at this question of, is the consumer, was this a defect? And the whole point of it.
Are those guidelines available to the consumers?
These are dealer guidelines. No, they're not. They're not something I mean, they're several pages long. It's
Okay,
something.
so if I sued GM under this program, and maybe you probably waived it at this point, but if I sued GM under this program and demanded that those guidelines be put in evidence, what would GM's position be on that?
If the guidelines are in evidence, I mean, those guidelines are part of the program. They certainly are an indication of what dealers and GM should be doing under this program. Whether they're definitive, I don't know the answer to that, because good faith is a determination.
Okay,
based
but the
on
guidelines aren't given to the customers,
No, they're not.
and the general customer's not going to know what these guidelines are.
The guidelines aren't published. But I mean, you know.
Okay, it goes back to the question. I want you to address this. Your time's running out.
Okay.
Because you started to address it, that can a benefit that people don't know about, can that be part of the consideration?
I think absolutely, Your Honor. Let me just give an example. I go into the store and I buy a cell phone. And what I really want is the cell phone, a functioning cell phone. I get home, I open the package up, and to my great surprise, there's a car charger in there, or an insurance plan covering the cell phone. I didn't know about it at the time of purchase, but I paid extra to cover those amounts, and the state collected tax on that. That's a benefit that was provided to me, whether I knew about it or not at the time of sale. And so what the customer knows is really not the relevant question. The relevant question, this is a tax case, it's about pyramiding. The relevant question should be whether this is a benefit that's provided to the customers at the time of sale. And the evidence that GM has incurred over $400,000 in these repairs at a cost of $293 million.
Okay, but you
Counsel, just a follow-up question to Judge Van Norbert's question. If we follow the Ohio and Michigan Supreme Court's view, you win.
Yes, Your Honor.
Right. Now, Michigan was construing this good faith requirement under Michigan's law, as Judge Freiberg noted. Can we reach an exact different result construing this good faith service requirement under Florida law?
I don't believe so, Your Honor.
Why not?
The law in Florida is the same. If you look at the Cox case, the Seat case, all of those cases talk about, number one, the implied duty of good faith attaches to every contract, and that includes discretionary obligations like this one.
Yeah, and let me go back to your car charger thing, because that seems to be a little different, because the car charger is something tangible I'm getting in the package. I mean, I'm getting the benefit of having that car charger there. I think the state's arguing, well, if I have all these car chargers and I'm not providing you in the package, and I'm holding them back, and later on you make a claim for those car chargers, I may or may not give you one, is that a benefit that passes at the time that the original sale was made?
I think the example shows that it's not necessary to have notice of the program. The important thing is whether you're getting it as part of the sale. There's no question here. This program has been in operation for decades. GM has provided thousands and thousands of repairs.
So the bottom line is you're getting something, and then the question comes down to that we have to decide, and I guess the trial judge decided, is whether that has to be something you're getting that's legally enforceable.
That's right, and we believe it is based on the trial court's reasoning in the Michigan Supreme Court.
Counsel, just before you answer the question, one final question. Although this issue has not been addressed, reference to the affidavits of McCusker and Kiefer, which was raised as an issue on appeal. Assume for the sake of argument the trial court did not err in admitting those two affidavits, and they of course involve the fact that, or the point that these goods were taxed, added to the cost of the car at the time of purchase. Would that be assuming that is the case, would you win, first of all?
I do believe we win, Your Honor, because it's a legally enforceable obligation.
Second point, if you win, would that be a tipsy coachman basis for affirming the trial court, or would that be based on the order of the trial court?
Your Honor, I think the tipsy coachman, that they can be affirmed on for any reason, I think, yes, potentially. I think that evidence in particular, if you look at the Ohio case, the Ohio court emphasizes it very strongly. The Michigan
But my
court...
question is, would that be a tipsy coachman basis for affirming the trial court, or was that based on the express wording of the trial court's order?
I think it would be both, Your Honor, because, number one, it shows definitively that the cost of these programs were included in the price, and therefore, by taxing them again, there's pyramiding in violation of state statute.
Okay, I'm going to interrupt you, and you're going well over your time, but this is a complicated issue. Trial court specifically rejected that argument. The fact that GM estimated and factored into the price it's charged for the vehicles, the cost of the goodwill repairs, is not controlling. So I think the answer to Judge Lewis's question then, wouldn't it be that if we affirm on that basis, it would be based on tipsy coachman, because that's not what the trial court ruled.
Your Honor, I'm responding to if the court were to agree that the evidence came in, but were to disagree with the trial judge, that there was some sort of legally enforceable obligation, my point is that this court could still affirm on the basis that that evidence shows that these repairs were included in the price of the vehicle and therefore were taxed at the time, regardless of whether it was legally enforceable.
And if they were taxed at the time, would this new tax be a pyramiding tax, is what you're saying?
Yes, Your Honor.
That would be expressly prohibited by the statute?
Yes. 212.12, subsection 12, and 212.06, subsection 4.
Okay. I'll give you 30 seconds. Since we've kept you over, I'll give you 30 seconds to...
Your Honor, I think we've covered the main points. I think the important issues here are addressed both thoroughly in both the Michigan case and the Ohio case. The trial court emphasized the Michigan case, which we think is most on point because obviously it involves the exact GM program. So we ask that the court affirm.
Okay, thank you. Okay, could the clerk add 5 minutes to Mrs. Nordby's time, although she doesn't necessarily have to use it all?
Counsel, we'll again assume for the sake of argument that the trial court did not err in admitting those two affidavits in question. Do you lose?
No.
If not, why not?
No, Your Honor, because Florida courts have already rejected arguments similar to General Motors regarding tax liability for the cost of items that are built into the retail price. And they have consistently held that there is no pyramiding or duplication of sales and use tax when there are separate transactions involving separate taxable privileges and separate taxpayers. And here we have a perfect example of separate transactions. You have a dealer sells a vehicle to a consumer at retail. Sales tax is assessed on that retail cost on the privilege of purchasing something at retail in the state. Years later, if that consumer is fortunate enough to receive a goodwill repair, then the dealer performs the repair, doesn't charge anything to the consumer. It submits a bill to General Motors. General Motors reimburses that dealer for the cost of the repair. And that is the transaction that we're assessing use tax on, that reimbursement, because General Motors is exercising use over this tangible personal property that's installed in these cars. And that's a separate transaction involving the separate taxable privilege of using tangible personal property in the state. You have two taxpayers, two transactions, two taxable privileges. There is no duplication or pyramiding of tax in this case. Now, and Judge Wolf, you hit the nail, Judge Lewis, I'm sorry, you hit the nail on the head when you brought up the point about three identical consumers could purchase the same car and after the warranty come in with the same identical problem. And there could be, under their program, a disparity of outcomes. And that emphasizes the problem with their argument by saying everyone purchases this right. Not everyone receives a goodwill repair. They have no knowledge of the subjective standards used.
I guess GM's argument, though, would be we gave them the right to make sure we have a look at it. Not how we're going to ultimately come out but it is a benefit that we are going to review it.
It's not an enforceable benefit. It's just an
Well, it's an
illusory.
enforceable benefit if they say, okay, we're not even going to look at it.
So
So you have an
basically,
enforceable benefit to make them look at it.
but to be valid legal consideration, it has to be enforceable. It has to be.
But I'm saying it's enforceable to the extent that, GM, you haven't even looked at it. And then the trial court and the Michigan court has read into that, you're going to look at it in good faith. You see what I'm saying?
I
You
understand.
purchase the right to have them look at it, and you have the right, further right to have them look at it in good faith.
But essentially, they're saying that you're purchasing a right to complain, and no consumer needs to purchase a right to complain. That's inherent in being a consumer.
Yeah, well, you're purchasing more, because if you come to my door and complain, I can say, get the hell out of here. Now, GM saying, you're purchasing the right for me not to say, get the hell out of here. I'm going to let you, get in the door and talk to me about it.
But even the way GM has established this program is that they have ultimate discretion over who gets these repairs. There is nothing enforceable about it. And it's important to note,
But
in
if
these,
they're arbitrary and capricious, they're not acting in good faith. That's what the case law says. And doesn't the good faith, if you've got a contractual obligation to consider on a case-by-case basis, then they have the discretion to make the repair. That discretion cannot be done in an arbitrary or capricious manner, or it violates the covenant of good faith and fair dealing. And that's
Yes.
their argument. Why isn't that argument compelling?
because the implied covenant of good faith and fair dealing, it has got to be anchored to an express term and promise in the contract. And here you have no promise. There's nothing anchoring.
Their argument is there is an express provision that requires GM to consider the complaints on a case-by-case basis. Then they have the discretion to make the repair, but they have to consider the request and the claim.
Yes, if you look at the case law that Counselor mentioned when he was up here, Cox and Sapie, and all the other cases cited in our briefs where courts have found that the implied covenant applies. In each of those cases, there's a very express statement and promise. In Cox, it involved caseload assignments from a trucking company to truck drivers. And in that contract, it said, we shall assign you caseloads. However, you don't have to accept the caseloads, and we don't have to give you a certain amount. There was an express promise to assign caseloads.
But let me go back to the 2002 language, because I think that's probably the most difficult for you to get around. Because it not only says that we're going to look at it, but it kind of, I almost wish I'd asked this question to the other side, but it seems to me that a weakness in their argument is, okay, you're going to look at it, but unless you know what the hell they're looking for, the fact that they're saying they're going to look at it is not real good. But in the 2002 language, it specifically says what they're going to look at. They're going to look at to see whether there's a defect, a problem resulting from a defect in material or workmanship. So it goes, a little bit further than anything else. We are going to look, we promise you, we're not going to throw you out. We're going to look in good faith to determine whether there's a problem from a defect in material or workmanship. Why isn't that a specific enough promise to tie the good faith to?
Two responses to that. First and foremost, even though they say we're going to look at the defect in material and workmanship, there are other things that they don't tell the consumer that they're going to look at. Specifically in their dealer self-authorization guidelines, which are on the record at page 630, in describing to dealers what to look at, what to assess, and who gets these repairs, they have very subjective standards, and they say when you're negotiating with a consumer about if they're going to get a repair, determine what they expect, determine if they're a deserving customer, evaluate the reasonableness of their request, determine what offer would satisfy the customer. It's consumer specific. It's not a right that everyone has equally. It's only if after the warranty they come in with a problem, the dealer thinks they're a deserving customer, So there is no promise established in the 2002 warranty manual relating to anyone being guaranteed to receive a repair or even knowing how they're going to assess who receives a repair. Additionally, the second response, what is helpful in analyzing the 2002 language is to look at the Owen cases we cited in our briefs. And the Owen cases, they addressed General Motors' special policy adjustment program, and in the warranty manuals, there's language addressing the special policy adjustment program. And it's very similar to the language in the 2002 Pontiac manual. And in the Owen cases, you had car owners bring breach of contract claims based on the implied covenant of good faith and fair dealing, asserting that under this language, General Motors breached the contract. And the district court and the Eighth Circuit Court found that no, this language that talks about the special policy adjustment program, which is very similar to the 2002 language here, all it does is give notice that at some point in the future, General Motors might do something for the benefit of its consumers, but it might not. There's nothing that you can base the implied covenant on, and General Motors, in not issuing these consumers a special policy adjustment, have not reached the contract.
This 2002 warranty language booklet remained the same or changed throughout the relevant period in question?
It has, you mean the language concerning case-by-case adjustments?
Warranty, that's right.
Yes, it has materially changed throughout the warranty period, and it was interesting. In the Michigan case, yes, they were addressing an earlier version of the warranty manual. But in that case, they didn't just find notice, they found an express promise. And if you look at that language, there is no promise there. And additionally, the Michigan case, it was not clear if they had the 2000 Chevrolet manual in the record before them. That 2000 Chevrolet manual says nothing about any repairs or assistance after the warranty period. It is very materially different from this 2002 language. So, under Florida law, there are separate transactions involving separate taxable privileges and separate taxpayers, and the department respectfully requests that this court reverse the trial court's decision.
Okay. Well, thank you very much. Both sides did an excellent job in this case. And I guess our day of beating up on the Norbies is done.